how to raise capital for your co-op, but what I'm really going to talk about is how to legally raise capital, which isn't as uplifting a topic. But there are a lot of legal constraints on capital raising, so it's just really important that people know about them before starting any kind of capital raising campaign. And then I will talk about some ways that you can raise capital within the law. So how many people know what is a security? Careful, that looks a little unstable. How many people know what is a security, legally speaking? Nobody, okay.
It's an investment in a company?
Exactly, so it's a legal term, and it basically means any type of investment in anything. It doesn't even have to be a business, it could be any type of activity. And so if something is it's important to know if something is or is not a security, and it's not always super clear what is or is not a security. And there's different definitions, there's federal definitions and state definitions. So, and because when you are dealing with securities, you do have to worry about the federal law, and you also have to worry about the states where you're offering your investment. So I just want to kind of give you a quick primer on what is and is not a security. A lot of people have a lot of misconceptions. They think, oh, if I just offer small loans to people, that's really not probably I don't have to do any legal compliance work for that. I only have to do that if I'm offering stock in a corporation. But that's not true. It is quite a broad definition. So the federal definition is a contract, transaction, or scheme whereby a person invests his money in a common enterprise and is led to expect profits solely from the efforts of a third party. So basically, anytime you put money into something and you're expecting to make a profit off of it through the efforts of someone else. If you try to offer investments to someone and you claim it's not a security and you get in trouble, some of the things that might make it more likely to be seen as a security is, do people have a right to receive dividends? Can people take that investment, the document that evidences the investment, and sell it to someone else or trade it? Can you use it as collateral? Do you have voting rights? Can it appreciate in value? What your motivations were and what the company's motivation was? And does it pose a risk? Because the whole reason why we have these laws in the first place, they were passed in the 30s, and they're designed to protect investors from bad investments. So, and then even a loan can be an investment if you're raising money through loans for the purpose of developing your business. If you're just doing like a consumer loan, or like a loan for short-term financing of you need a little bit of extra money to pay your payroll or whatever, that would not be considered a security. But any loans that anytime you borrow money to develop your business, that's also security. So basically the point of that is that there are a lot of things that are securities. Whenever you raise money, it's often going to be considered a security under federal and or state law. There's federal and state laws that govern securities. And the laws were passed mostly in the 30s. We all know what happened in 1929. There was a big crash. So these laws were passed to protect investors. So the idea is that before you offer an investment in your company, you're supposed to do a lot of work to disclose what it is that you're offering, and maybe even get the approval of a state or federal government agency before you can even offer any investments in your company. So the basic rule, if something is a security, you have to do what they call a full registration. And if you've heard of an IPO, that is a full registration. And a registration at the federal level and also at the state level is where you create a really detailed disclosure document all about your business, your financial performance of your business, the risk factors. You have to put all these risk factors in there saying this bad thing can happen and that bad thing can happen. And it's a very long document. You have to file it with the federal and state regulators, and to do that, it's basically doing an IPO, and as you probably know, doing an IPO can cost at least like $100,000 in legal and accounting fees. You have to have audited financials. So obviously not everyone who raises money is going to do all of that. So luckily there are some exemptions to that general rule. But even the exemptions are really, really complicated and somewhat hard to comply with at times. So when you are when you're wanting to raise money and you know what you have is a security, you have to start thinking about what exemptions might I qualify for. So the first thing you need to be aware of is there's something called an accredited investor. An exemption is something that allows you to not have to pay that hundreds of thousands of dollars to do the full filing with the securities regulators. So to qualify for an exemption, to know whether you qualify for an exemption, you need to be aware of this thing called an accredited investor. An accredited investor is someone who has at least $1 million in net worth, not including their primary residence, or has at least $200,000 a year in annual income. And it has to be consistent, not just 1 year. Or it could be a company or a nonprofit that has at least $5 million in assets. So basically, it's the wealthiest possible people and institutions in our country. We estimate it might be maybe 2% of the people in the country actually meet that definition. If somebody meets that definition, you, as someone who's offering an investment, will have a much easier time of complying with the rules required to do it legally, because there's this idea by the regulators that somehow people who have that much money are savvier investors. So just by virtue of having that much money, there's this idea that they don't need to be protected as much. So when you look at the standard way of offering investments, a lot of times people will say, oh, I'm gonna find a venture capitalist, or I'm gonna find an angel. Those people are all accredited investors. And to offer investments to those people is fairly easy because, like I said, the government assumes that those people don't need a lot of protection, so you just have to do a very minor filing and it's not a really big deal. But the minute you want to be able to have people other than the richest 2% of the people in the country invest in your business in any way, then you have to start thinking about, gosh, how the heck am I going to do this within the law? So like I said, you have to think about both the federal and the state exemptions every time you do a securities offering. There are both federal and state exemptions. There are exemptions where if you offer your securities just privately and don't advertise it to the general public, there's an exemption for that. If you only raise up to $1 million or up to $5 million, there are exemptions for that. There's also there's something called the federal intrastate exemption, which means that if you are a very local business, you're very focused in one state. So you formed in one state, most of your customers are in that state, you spend most of your money in that state, and you only want investors from that state, you actually don't have to worry about federal securities law, which is really nice. So that's a nice one that a lot of us will easily qualify for because a lot of us are small local businesses. There's also exemptions for charitable organizations at the federal level. So if you're a nonprofit and you want to go out and get a whole bunch of loans, under federal law, you're exempt from that big registration requirement that costs hundreds of thousands of dollars. There's also a federal exemption for agricultural co-ops, certain types of agricultural co-ops. And then, okay, so let's say you figure out, you know what, I'm a small business, I'm totally based in California, I really don't do any business outside of California, I'm incorporated in California. I qualify for the federal intrastate exemption, so I don't have to worry about federal securities law at all. You still have to worry about state. What do I do in the state? And California, as you might guess, is one of the toughest in terms of regulating securities. There is an exemption for small offerings for people that you know really well. So the rule says the people have to know you, they have to know you well enough to know your business acumen and your financial situation. So it's actually a pretty strict rule. So you can't just, go to a few networking events and run into someone a couple times and say, hey, you want to invest in my business? Under California law, you're not supposed to do that. Sometimes they call it the friends and family exemption. It's really only for people that you already know quite well and that know you very well. So that's really tough because a lot of people don't know that many people that well that can invest in their business. And then even if you do, you can only have up to 35 unaccredited investors. So now, in California, so co-ops, I'm sure you were wondering if we would ever get to co-ops. Co-ops do have a special exemption under a lot of states have exemptions from the securities law requirements for co-ops, and every state is different. In California, if you offer securities if you offer memberships for your co-op that cost no more than $300, you're exempt from the securities laws. So you can go out and bring in members, whether you're a consumer co-op, a worker co-op, a producer co-op, whatever. You don't have to worry about the securities laws as long as your membership fee, and this is $300 total. Like you can't say $300 this year and then you got to pay another $300 next year. No, it's $300 total at any given time for any member. So as long as you stay under $300, you don't have to worry about the securities laws for your members. So that's a good thing. And then what you can also do, and one other thing I should mention about the charitable exemption. In California, there is no charitable exemption. So if you're a nonprofit in California or even in another state and you want to raise money through loans, you actually do have to do securities compliance work under California law.
Yeah, the federal ones though for being a charity or not?
Yeah, the federal one you have, but not the state one. And you have to comply with both. In California, you can actually go ahead and do a full what they call qualification, which is where you go ahead and you actually file all the documents disclosing everything about your business, your financial situation, all those risk factors of things that can go wrong, and submit that to the state and ask them, can I please offer securities, based on this description of what I'm offering? And you describe in that document, am I offering loans? Am I offering, memberships? Am I offering memberships of more than $300? Am I offering common stock in my corporation? Whatever. So you describe all that, and then the regulators look at it and they say, well, we think this is a little bit risky. We're not sure we really want you to offer this to California investors. So that's tough. If you don't have somewhat of a track record, it's almost impossible to get the okay from the state regulators to actually offer your investment to a broad range of people in California. So if you're operating for a while, like I have one client called Equal Exchange. Has anyone heard of Equal Exchange? So they're a worker co-op. And they've been around for 20 years, and actually they haven't gone out and done a public offering, where they do that full registration process. But if they did, I'm sure the state would be fine with it because they have a 20-year track record as a successful business. So they've raised money in other ways. So there are, you can use some of these other exemptions to get started, these like the private exemption. And then after you've been operating for a few years and you have a good track record, a few profitable years, then you can go ahead and do one of these public offerings. Now we're going to get into some of the ways that you can raise money if you don't want to go for that more traditional financing that businesses often try to go for, which is venture capital, angel investors, and banks. So, especially because we live near Silicon Valley, you're always hearing, I don't know, you might not hear it as much as I do, but being a lawyer near Silicon Valley, you're always hearing about I'm going to, go to this thing where I'm going to do my pitch and I'm going to, hopefully an angel investor will invest in my business, or I'm going to go to this VC on, what's that street in Palo Alto where they all are? I forget. Sand Hill Road or something, and I'm going to go down there and I'm going to get millions of dollars from them. And a lot of people are really questioning that model as a way to get money into a business because, one, it's very hard to get. Even if even if you want the money, they are very, very selective in what they'll put their money into. They won't put their money into a startup. Same with banks, They want to see a track record. And also they want to invest, the VCs and angels want to invest in a business that's going to grow like crazy and has the potential to be bought by Google, And guess what? 99% of businesses are not that, and thank God, because if they were, then our planet would implode, Most businesses don't grow like that. We just steadily, little by little, maybe grow a little bit, or maybe we don't grow. Maybe we just stay the same year in, year out, and everything's cool, But maybe we need some capital. So angels and VCs are not going to be interested in that. Banks right now, it's very hard to get loans from. So in Cutting Edge Capital, we started Cutting Edge Capital to really help people consider other ways of raising money, which are legal. They are within the law, but they also don't require you to go for that kind of money. So we have 5 categories of these ways to raise money without angels, VCs, or banks, and to do it legally. So the first category is what we call the non-securities category, and that's where you take advantage of the definition of a security and you find a way to raise money that doesn't fall into that definition, so you don't even have to deal with that law and all that compliance work. The second category is co-ops. And some people say, well, why would you list co-ops as a way to raise capital? Because I do this presentation for non-co-op audiences as well. And the reason is that co-ops have ways of raising capital that other businesses don't. So if you want to be a co-op, it actually opens up some opportunities for raising capital. The third category is grants and public-private partnerships. The fourth category is private offerings, where you do one of those offerings, like I said, where you don't advertise to the public and you can only have up to 35 unaccredited investors. And then the fourth category is a direct public offering, where you actually do advertise to the public. So I'm going to go through all 5 of those. So for non-securities, ways to raise money without having to worry about the securities laws. And of course, you never know for sure what you could get in trouble. It is possible that you could come up with a scheme that really seems like this is not a security, and you never know. Like, I'm not promising that some court or some regulator won't say that was a security, but these are just some things that we've seen done successfully, and that some are more and some are less likely to be totally safe in terms of not having to deal with securities compliance. The first one we call pre-selling, and people also call it like gift cards, where you have like Awaken Cafe is one example I use, but a lot of businesses have done this. I think Cafe Gratitude did this as well. So you are ready to start your business, you don't have enough money to open your business, but you just know it's going to be really successful. People are going to love it. They're going to just be so thrilled to go to your business. But you need to raise money. So what some of these businesses do, what Awaken Cafe did, is they created these cards that were like gift cards for their business, even though their business hadn't opened yet. And they sold them at a discount. So I think they sold $1,000 cards. They were called Cafe Creator Cards. They sold them for $800. So they actually raised enough money to open their business. So of course, it can be a little tough if you have a ton of people with these cards coming into your business all at once and you don't have a lot of cash coming in, but it worked out really well for them. They're now expanding and they've done really well. So arguably, that's not a security because you're not selling an investment. You're selling a gift card for coffee. Another thing you can do to stay outside of the securities laws is donations. So there's absolutely nothing illegal about raising donation money for your business. That's not going to be considered a security because obviously no one's going to donate money to your business for the purpose of an investment. They're not getting anything back, So there are more and more platforms set up to facilitate that kind of thing. Indiegogo and Kickstarter are two of the more famous ones where you can actually put information about your business, or it doesn't even have to be a business, it could be just a project that you're doing. You put it up on that website and people can donate money to your cause or to your business.
Can you name those two again?
Kickstarter and Indiegogo.
Kiva is something that's pretty big, isn't it?
Kiva is actually different. I'm going to get to Kiva in a second. So businesses have raised money using these platforms if you tell a really compelling story, and also if you offer some kind of gift, like a t-shirt or an invite to an event or something like that. Some businesses have actually raised quite a lot of money. Like, there was one called Little City Gardens in San Francisco that raised a lot of money. I think, $16,000, all in donations. Another example of ways to avoid securities law is selling a discount card. So like Costco is kind of an example of this, where you sell a membership in Costco and in exchange for your membership you get discounts. So that, obviously they're not selling them for a lot of money, but they can accumulate a fair amount of money by selling these discount cards. REI is another example of that. So they sell these memberships, and REI is a co-op, and they sell memberships, but the memberships, they don't consider it a security because they say all we're really selling when we sell memberships is the right to receive money back at the end of the year, which is basically a discount. So they actually consider it very similar to what Costco does, but they just give you the discount at the end of the year in the form of a dividend instead of giving it to you, every time you shop. Another example is Kiva, and that's where when someone puts money in, you only promise to give them their principal back, no other return, no interest. So when you put money into Kiva, all they promise is the money you put in, you can get it back, but nothing beyond that. If they offered interest, then it would be subject to securities laws and they'd have to do a ton of securities compliance work. But because they're not offering any return, they feel confident, and this is one where who knows, maybe someday someone will sue them for this, but they feel fairly confident, I guess, that I don't know them, but I'm assuming they feel fairly confident that it's not a security because they're not offering any financial return. So obviously people must not be motivated by making a financial return, so it's not a security. What if you offer some kind of benefit based on the success of the business? Like, if our business is successful, you'll get a t-shirt or you'll get a gift card. And that's, it's a good question. I think if you're offering something of value that could easily be converted into cash, I could easily see the securities regulator saying, what's the difference? If I invest $1,000 in 1 year they give me $1,100 back, that's definitely a security. If I invest $1,000 and in 1 year they give me $1,000 plus a $100 gift card, I can't believe that the securities regulators wouldn't say, that's pretty similar to just giving you cash, So I think that's on the riskier side. So, and that's actually something I've really tried to research. If you say to someone, give me $1,000 and in 1 year I'll give you your $1,000 back plus a $100 gift basket.
So how is that different from a discounted card where you're buying it for $800 and you're getting $1,000?
Yeah, exactly. That's a good point. That could have been seen. That was a little risky, I think. Nothing happened. They weren't my client when they did that. I don't know if I would have.
If it's coffee, you can't resell it, so it's maybe harder to.
Yeah. See, these are all things that, unfortunately, there's a lot of gray areas, and there's not. I was looking at some cases recently, and especially, for co-op, all of these things, there's very few published cases on them. Like, I think there's only 2 Supreme Court cases that have ever dealt with co-ops and securities law, So it's so hard to know exactly what could happen. The thing you have to think about, though, is what is your risk? If you are really confident that everyone's going to be happy, that you're going to be able to fulfill your promise to them, that they're going to be able to get their $1,000 worth of coffee, chances are you'll be okay, because the way people get in trouble is when they don't fulfill their promises and someone gets really mad and calls up the regulators. But if everyone's happy chances are you'll be fine. So it's kind of, you have to weigh the risks. You can never be 100% sure that you won't run into securities law problems. And plus, there's other problems you could run into. Even if it's not a security, they could sue you for fraud, or they could sue you for breach of contract, or emotional distress or whatever. So, you're never 100% safe from being sued. But the idea is, if you think that what you're offering, you can make a pretty good argument, it's not a security, it doesn't fall in the definition of a security, and you're pretty confident that everyone will get what they're expecting to get, you can, I don't want to tell you, for sure you'll be okay, but you could be fairly comfortable with that. So, let's see. Another thing that's interesting with co-ops is, I work with a lot of worker co-ops, and a lot of worker co-ops in this area, they are very democratically run. So instead of having the members elect a board, they actually they make it so that the members are the board. So basically the entire population of the workers, the members, not all the workers might be members because they might be on a probationary period, but everyone is actively involved in managing the business. In that case, you're probably pretty safe from securities law, because if you remember what I said earlier, part of the definition of a security is that you're giving money to someone else with the expectation of getting a financial return through the efforts of others. So if you're actively involved in running the co-op and you're on the board, chances are you're in pretty good shape from the perspective of securities law, because it's not, you're putting money in, but you're also actively involved in making that business successful.
What about the $300 cap for worker co-ops? Does that apply?
Yeah, so I would say, and don't, say that this is like the rule of Jenny, it's just my guess, that you wouldn't have to worry about the $300 cap for worker co-ops where the workers are all on the board, because they're all actively involved in the management. So arguably, it's not a security at all.
The $300 from the worker owner, not from the worker owner's friend.
Right, exactly. So if let's say I'm starting a worker co-op and I'm going to have 5 people and we're all going to be on the board. And we've decided we're each going to put in $1,000. So I don't qualify for that $300 exemption from securities law under California law. However, I would think that it would still be okay to have everyone put in $1,000 because they're all actively involved in the management. So arguably, it's not a security.
So if you're a worker-owned co-op and you sell memberships for $500, that's not going to be okay because the members are not actively involved in the success of the business?
Well, so if you're a really big worker co-op, like one of the ones in Cleveland, let's say that the laundry in Cleveland, every worker in that laundry co-op is probably not actively involved in the management. It's very big. I'm sure they elect a board, and the board is who really runs the co-op. So I would say in that situation where it's a big co-op and not all the workers are actively involved, then you would want to find some other way of making it legal to offer them memberships if you wanted to do it, if you wanted to offer memberships over 300. But if it's a small co-op where everyone's actively involved in the management, I would argue that, you don't seem to be buying it, but I would argue that it's not a security, because, it's kind of like when you start, let's say you and a friend start a corporation together. No one's going to say, oh, you and your friend can't issue yourself stock in your own company because you are the owners, you are the founders, you're running everything. That's not really.
That's just capitalization, right?
Yeah. You're capitalizing your own company. So I'm sure there's a certain line where, like, if it was 15 workers, maybe it wouldn't look as good. I don't know. Anyway, this is what Tim Hewitt believes. You know that Tim thinks that. So Tim Hewitt's another co-op lawyer, and he has always felt that because in these worker co-ops where all the workers are on the board, everyone's actively involved in the management, he believes that securities law doesn't apply. So it's not just me who thinks this.
Don't a lot of co-ops actually use that as like a way of being inducted into the co-op, like a buy-in? Is it Is the buy-in a type of exempt security?
Well, a buy-in is basically what you're paying for your membership.
But that's not a security.
So what I'm saying is that if you're actively involved in the management, that you could argue it's not a security. However, if you aren't actively involved in the management, it would be a security. Because if I work for a 100-person co-op, and they say, okay, give us $1,000 to join, then there could be an argument made that I'm making $1,000 investment in a business that I don't really control. And then it would probably be covered by securities law.
Or as many as a $2,000 buy-in, isn't it? And Evergreen is $1,000 or $2,000 buy-in as well.
Okay, yeah. So, yeah, and I know Tim Hewitt definitely, he was, the lawyer that's pretty much created the Arizmendi legal model. He takes the position that they don't need to worry about securities law. Who knows, maybe we'll find out we were wrong and then we'll deal with that then. So let's see. So those are all ways, and you can probably think of other ways, get really creative, of ways to bring in money that does not involve the securities laws. These are just some ways that I've thought of, I'm sure there's a lot more people could think of if they're creative. Another example actually is a CSA, a community supported agriculture, where people pay up front to get a box of produce later on. That's another way, is that you're paying for your box of produce and the farm is raising money, but arguably it's not a security because you're not investing in the farm, you're just buying produce. Right, prepaying, exactly. Okay, so now we're going to get more into co-ops. So, and I have to say that I've just found out some things. I just read a state case that has very much concerned me. So I've kind of revised a lot of what I'm saying about this stuff, but let's see. Okay, so basically, like I said, there's the whole thing where if you're a worker co-op and everyone's actively participating, arguably not a security. There's also state exemptions, and every state is different. Our state is some states don't have any exemption at all. Like Louisiana, I've just been working with someone in Louisiana, they don't have a co-op exemption from securities law at all. But other states like Massachusetts and Washington and Colorado have really broad exemptions for co-ops, where they say not only is a co-op membership exempt, any security issued by a co-op is exempt. So that means you could do a member loan program, you could offer investments to outside investors that aren't, your patrons. So that's really cool. But of course, in California, we don't have it that good. We have this thing that says, the exemption says if the member only puts up to $300 in, it's exempt. But this has, that doesn't mean if you do a member loan program or bring in other types of money that's not membership money, then there's no exemption. So, like I said, there is a federal exemption for ag co-ops, for farming, fruit growing, or similar types of co-ops. Organic Valley uses that. Okay, so here's where I'm starting to I've learned something that's making me rethink some of what I used to say. Actually, I was at the California Co-op conference in Berkeley a few months ago, and I said, the definition of, there's a federal case called United Housing versus Foreman. And this case says, I'm glad not everyone's asleep right now. So this case says that if you put money into a co-op, and your purpose for putting the money in is not to get a financial return, but it's to get some other thing like housing or, buy organic food at an affordable price or whatever. So under this federal case, it says that would not be covered by securities law. Even if you do get some kind of a return on that investment, if your main purpose for making that investment is something other than getting a financial return, you don't have to worry about securities law. So like if I join a food co-op and the joining cost is $1,000, that wouldn't be a security because my main purpose for joining is to get the good food, even if I get a financial return. So that's what I used to say, and I stood up in front of this conference in Berkeley and said that. And someone was like, wait a minute, that's not true. If you ever charge more than $300 for a membership in California, you're going to be in trouble with the securities laws. And I was like, okay, let me look into that. Maybe you're right, because I realized that's a federal case. What about the state, right? So we're subject to state law. So I did a little research, and lo and behold, there is actually a very bad state case. And what happened in that case is these people in Marin were creating a country club. And they said, and this is exactly what I always. So they said, oh, we have a really good idea, right? We're going to sell charter memberships before the country club is done. Sounds very reasonable. They didn't offer any financial return on the membership. You would pay like $150 for a charter membership. And in exchange for that $150, you would get to use the club once it opened. And the club developers used that money to develop the club. So you don't have any ownership interest, you don't get any financial return. Believe it or not, the California Supreme Court said, yes, that is a security. So even though it doesn't have, it totally goes against what the federal law says, which is, the federal law says you have to be making an investment with the purpose of getting a financial return. And also there's that other case that says if you're putting your money in to use the club, not to make a financial return, it shouldn't be a security. Well, in California, there is precedent that says that could be a security. So that's really freaking me out right now, because I'm thinking, like, basically what that case is saying is if you ever raise money for the development stage of your business, so like the startup or expansion, like if the purpose that you're raising the money for is to either develop your business or to add some new part onto your business, then that's a security. So I have an intern right now researching some more about this, because it can't be that broad, because that would almost mean that would mean almost everything is a security. So even like Indiegogo and Kickstarter could be a security, because you're not getting any financial return, but you're putting money into things for the purpose of developing a business.
So if there is a incubator fund or something created by co-ops like they do with Arizmendi, and that money is coming to start a business, can that somehow be considered security because the money is coming from somewhere else, from some other entity?
That would still be subject to the securities laws, just like anything else would be. The fund to bring money in from the fund, they'd have to comply with securities laws. So.
Unless that fund had over $1 million, could that fund be called an accredited investor?
It would have to have over $5 million, because an accredited investor is an individual with over $1 million or an entity with over $5 million.
How much did you say the country club was getting from?
There were 3 levels of membership, and this was back in like 1960. But there were 3 levels of membership. It was like 150, 250, and 350 or something like that. So it's pretty bad. So I'll try to, once I find out more, I'll let everyone know. So I mentioned member loan programs. So member loan programs are securities. You do have to figure out how you're going to comply with the securities laws when you do member loan programs. Most co-ops don't, and they don't ever get in trouble, but really, they could. I actually know there's a co-op in Placerville, a food co-op, that actually did it right. I was really impressed. What they did is they applied to the state to do their member loan program, and they've completed that whole form where they talked about the risk factors and the business plan and the they actually, it's a new co-op, but they purchased an existing store. So I guess they had some track record that they could show because it was an existing store. And they actually got a permit from the state of California to do their member loan program. And they said it only took a few weeks. So, it is possible. Some people just say, oh, it's so hard, I don't even want to deal with it. But they did it without a lawyer. And they And they figured it out, so. Also, what about co-ops bringing in non-member investors? So, some co-ops, like for example, Equal Exchange, they have their worker members and then they have outside investors that just want to invest in the business. And those people aren't members really, they're investors. And so, again, that's definitely a security. You would have to do your securities compliance on that. And also with co-ops, actually, there are maximum amounts that you can pay to those kind of investors. Every state is different. In California, you can't pay more than 15%, return on those kinds of investments from outside investors.
I mean, what if it was a no-interest loan?
Then
There's no financial return.
Then arguably you'd be okay because, and again, I need to look at the case that I just, and the other cases that have cited that case. But based on my understanding, like Kiva, Kiva supposedly that's not a security because they're just promising your principal back and no interest. So I would say if it's a no interest loan, you'd probably be in good shape. We'll see. I'll get back to you on that. So then the third thing is grants and public-private partnerships. And I just like to mention this because it doesn't apply to many businesses, but if you have a partner who's a 501c3, you can potentially access grants. So the example I like to use is Mandela Food Co-op. So Mandela Marketplace is a 501c3 nonprofit. And they were able to raise a lot of grants and money from the city. And their purpose is to provide healthy food and job opportunities, job training opportunities in West Oakland. And so because the worker co-op, Mandela Food Co-op, helps them achieve that goal, they can actually channel grant money to the for-profit food store, so it's just something to keep in mind. If you happen to be doing something that might help a nonprofit meet its mission, it's possible you could have access to other kinds of money that you wouldn't normally think of as a for-profit business. And then number 4, private offerings. So this is what I mentioned before. In California, the only way you can do a private offering in California legally, and the good news is this exemption in California is actually if you can do it, it's very easy to do the compliance paperwork for. It's like a form that you fill out online and it only takes like 10 minutes to fill out. So this is the one where you have to know everyone really well before you can ask them for an investment. But there are some people who have done this successfully, like we have a client called Mill Valley Beer Works, and they're in Mill Valley, so they know a lot of rich people, and and so they were able to offer these loans. They said, they offered $5,000 loans, and they called it. They said buy a bottle or something, and so you'd give them $5,000. And they'd do some cute thing on their website where every time they got another 5,000, they'd cross off a bottle, and then they would, you would get some kind of interest rate and interest in return, and plus they would make a donation on your behalf to a nonprofit, and so it was this really cute thing, and they were able to do it because they did meet the requirements of the private placement exemption in California. And, like I said, they can only have up to 35 unaccredited investors, but you could have an unlimited number of accredited investors. Well, Awaken Cafe is doing the same thing right now. They're offering investments using the private placement exemption because they're growing now. They were really successful initially, now they're growing. Another Gather restaurant in Berkeley raised money from people that they know in a private placement, and they were really successful. They have a lot of, they have, I think, 200 different investors in their business because if you count spouses and stuff, so I think it's 65 investors, but if you count everyone, it's...
In a business where there are multiple owners, is it 35 unaccredited per owner or per business?
So per offering. So if you're trying to use the private placement exemption in California, you can offer it to people you know, that know you well, that know all, know your financial situation and your business acumen, and you can actually offer it as long as you do it privately, not with any kind of public advertising, but just talking to your friends and people you know. You can offer it to however many you want, but you can only accept up to 35 unaccredited investors for that offering.
So in a partnership where there are multiple, so it's per, like you can still incorporate, right? So it's that per that entity, 35.
It's not really per the entity, it's per the offering. So you could have multiple offerings as long as they're separated in time. So, 1 year you could do it, raise money, then like a year later you could do it again, have another 35. So it's actually per offering. But if they're too close in time together, they will consider it one.
Is there a time?
There's it has to be separated by 6 months.
6 months.
From the end of one to the beginning of the next. So then the last thing is when you actually go ahead and you do what they call a public offering, and that's where you actually can advertise to the public. You can actually like put it up on your website, you can, do a radio show about it. And that's for some reason the securities regulators are most concerned about that. A private offering, they aren't so worried about because they figure, it's mostly going to be people you know who know you. They probably are, they won't make a really stupid decision. But if you can send out mass emails to like everyone in California saying, hey, there's this great investment opportunity. You can make 100% of your investment in 6 months. That's where the regulators get really nervous. So to be able to do public advertising, public offering of your investment, that's where it really gets intense in terms of the compliance that you have to do. And that's what I was talking about before, where you actually have to file something with the state explaining what your offering is, are you offering stock, are you offering loans, and what are the risk factors, and you have this very comprehensive document explaining all the risks and things that could go wrong about your offering. And then if the state approves it, then you can go ahead and actually offer your securities to the public. So not a lot of people do that, but like I said, it is possible.
There's a big cost associated with that process.
Well, okay, if you do it at the federal level, that's the full IPO, and that's like hundreds of thousands of dollars. But if you're just in California and you just do it at the California level, it may not be that expensive, If you qualify for the federal intrastate exemption, you don't have to worry about the federal securities thing. So,
is that just where you're raising money or where you're selling your products or services?
So the federal intrastate exemption, you can qualify for it. The best way to qualify for it is if you're incorporated in California, so you haven't formed under Delaware law or Minnesota law or whatever. You've incorporated in California, you only offer the investment to California residents. 80% of your assets are in California, 80% of your revenue comes from California, and 80% of the money you raise will be spent in California. So if you meet those, you're in really good shape to qualify for the federal intrastate exemption. And then you don't have to worry about the federal securities law at all. Then you just have to worry about California. So you mentioned funds. Funds are a whole separate thing that some people say like, okay, so Jenny, you're helping all these businesses raise money. Wouldn't it be better to just create a fund and have that fund be an accredited investor and invest in all these businesses? Wouldn't that be quicker and easier, right? The issue with that is that there's this whole other law that regulates funds, the Federal Investment Company Act of 1940. And if you're regulated under that law, it's very expensive. It's basically if you have a mutual fund, all the different disclosure rules and all these things, you have to have like a registered investment advisor on your staff and all this stuff. So you don't want to come under that law unless you have a huge fund and you can afford to pay for all that. There is one exemption. If you have fewer than 100 investors in your fund, then you won't be regulated by that law. But if you really want to do a very democratic fund where a lot of people are putting in small amounts of money, which is what I'm really excited about, like, you know, I want people, regular people, non-wealthy people, to be able to invest in their local community and invest in their local co-op and stuff. I want to be able to put in like $100 or $1,000 or whatever. So if you can only have up to 100, you're never going to raise enough money to actually be able to make a real big impact. So unfortunately, it is a little bit hard to have a fund, but there are some exemptions to that rule. There's something called the California Capital Access Company, which if you form under that law, and no one has done this yet, we are hoping to maybe be one of the first, that you can actually form under that law and you can actually sell shares to the public, and then you can invest in other businesses. And it would be regulated by the state. And the federal government says if the state is regulating you, we won't regulate you under that Investment Company Act.
Selling shares of your business as a worker co-op? Because only workers can have shares in their business in a worker co-op.
Mm-hmm.
So I don't get that.
Okay, so that's not really true. I mean, so let's say I started a California Capital Access Company whose sole purpose was to invest in worker co-ops. So I comply with all the requirements. You know, I do all the paperwork. I start my California Capital Access Company. I can sell shares to the public in my company. So I can just go out on the street or on the web or whatever and say, hey, invest in the California Capital Access Company. No minimum, you know. So let's say I raise like $10 million and now I'm ready to start investing in worker co-ops. So I actually can, because now I'm an accredited investor, so I don't have to worry about all the regulations. I can actually go and invest in worker co-ops, not as a member, but as like a non-voting investor.
So does the capital access company need to be capitalized to $5 million or more or something like that?
Yes.
To be accredited.
Not just to be accredited, but to even apply to be a California Capital Access Company, you actually have to raise $5 million before you can even apply. So this is something I've just found out about. This is like recent legislation, so I'm really hoping we can take advantage of that. What if we decide to set up a bank in our community to invest in worker co-ops? So a bank is a very different thing, and I don't know a lot about banking law. I think Mike Leon might be able to talk more about this, but a bank is a very different thing. It's really not regulated by securities law because it's regulated under a whole separate set of laws, banking law, which I actually know almost nothing about. But so to set up a bank is very hard. But once you set it up, you actually have a lot more things you can do. Well, in some ways more and in some ways less. The good news, you're very highly regulated in terms of what you can do with your money, but also you don't have to worry about securities law. So you can have depositors that put money into the bank, and you don't have to comply with securities law for them to put your money in the bank.
And
Yeah.
that's how the unified field bank works.
Right.
Well, the caveat is you have to raise equity for the bank, and
Yeah.
then you get hit by the securities laws there, so.
Okay. So yeah, I mean, you do have to raise equity for the bank, as Mike said, and it's a very complicated thing to set up, but it can be a great tool.
What if you get money from a credit union? You get a credit union to invest in your co-op.
So that's great. If you can get a credit union to invest in your co-op, banks and credit unions aren't subject to the securities laws. So if you get a loan from one of those types of things, then you're great, but they're hard to get. This is a really complicated area of law. Like, I barely touched the surface of it, and it's really frustrating that we have to deal with these laws just to raise money for our businesses. You know, obviously they were started back at a time when it made sense. You know, there was a real need to protect investors. But now it's kind of been co-opted, I would say, by big business. It's right now the only people that can really raise capital are big giant businesses that can afford armies of lawyers and accountants to deal with all these things, you know. So it's gotten to the point where small businesses have a lot of trouble raising money within the law. And then those 98% of us who aren't accredited investors, we have very limited options of where we can put our money. I mean, if you have any money, and I just looked at $166 billion in Alameda County is how much money is in bank accounts, IRAs, retirement funds. It's a lot of money, but think of where it is. If you have it's probably going to be in some big corporate bank, or it's going to be in a mutual fund, stock market, big giant corporations. And just think if we could take even a small fraction of that and invest it in our community, in co-ops. So one of the things I've been working on is trying to change the law. So I'm involved in a nonprofit called Sustainable Economies Law Center, and we actually did a petition to the Securities and Exchange Commission to change the law. We set our sights really low, and we just said, could you just exempt $100 investments? If we just said, if we only let each investor put no more than $100, could that be legal, So we haven't really heard back yet, although the head of the SEC did cite our petition in a letter she wrote to a congressperson who was asking her questions about this. And this cause is kind of starting to get some attention. But one thing we were when we decided to write the letter to the SEC, part of us was like, why should we write the letter to the SEC when we're really concerned about small local businesses who they're exempt from the federal securities law because of the interstate exemption? So really the important place to change the law is at the state level. But we decided to do it at the federal level just so we could maybe get some more attention to that issue. Because if you do it at the federal level, it's possible that people all over the country will start saying, yeah, why is it illegal for me to invest $100 in a small local business? That's ridiculous, And so, there's starting to be some attention to that issue. There were some congressional hearings that were held on it, and other people are starting to get really involved in the cause. And so now we're hoping this summer, because every summer we have interns, so that's when we really get a lot of work done. So we're hoping this summer to do some state level advocacy work, and it's possible that once we can get one state to consider it, we may get more, because there's a National Association of State Securities Regulators. So if we could get them to maybe create a model exemption, maybe a bunch of states would adopt it. And it's my colleague Michael Schumann, he's actually, a book that he's writing is coming out soon, kind of on this, a lot about this topic of where we should be putting our money to benefit our community economies. He says, why is it that we can go into a casino and lose everything without anyone handing you a prospectus saying, like, read 100 pages about all the risk factors before you go into the casino, But you can't invest in a small local business because, that's too dangerous, So we're trying to change the law. There was another company called Prosper.com, which does something similar. So when they first set up, they said, what we're doing isn't a security, it's loans. We're just giving the opportunity for people to make loans to each other. So they set up this huge platform to facilitate exactly what you're talking about, where there's, people who make their pitch and then other people who bid to, make the loan and stuff, and they got totally shut down by the federal securities regulators. So they had to completely shut everything down and do a full federal securities filing before they could go back and actually offer these loans. So I'm sure Lending Club, they seem a lot more savvy, so they probably did it from the very beginning. I'm glad you brought that up, because when people are they desperately need money for their business, it is a good place to look. I mean, it's going to be a fairly high interest rate, but it's legal because they've gone through the whole securities compliance process. And if you really want to start to learn about this stuff, you can actually go to their website, like go to Prosper, go to Lending Club, and look for that little link that says legal or, prospectus or whatever. And that's how you can really learn like how they actually do it. So it's not thousands of different offerings. It's all one offering of notes. And the notes are offered through one lender. So it's like some kind of, I don't know exactly how they do it, but when you lend money to someone through Prosper or Lending Club, you're not really lending directly to that person. You're like lending money to this one entity, and then that entity is lending money to the borrower. So you're saying that it can be really expensive to do these securities compliance things, but some people get so intimidated by it that they don't even consider it. And there are people who have done it and found ways to do it that they were able to do, and so I would say, never just assume, oh, I can't do this. If you really, really want to offer an investment to the public, look into it a little bit more. There may be a way to do it that's not that expensive. And there's this one thing, I didn't mention it because I kind of, without the PowerPoint, I feel like so much detail, it's not super clear, but if you're only raising up to $1 million, there is this exemption that makes it a little bit easier to raise money from the public. So there are ways to do it. So and one of our goals at Cutting Edge Capital is to get to the point where we've done it so many times that we can start to create almost like a template, even to the point where we maybe even have software like TurboTax for securities offering, where when we really understand it. And unfortunately, it's hard because every state is different, and we work in all 50 states, so we're like slowly learning about a bunch of different states. But hopefully, there is this one type of offering that's accepted in almost all states called the SCORE form. So you can actually do the same type of compliance work regardless of what state you're in, except California, of course. So we really want to make it so that anyone could do this as easily as possible. It's ridiculous. I mean, it's like a two-track thing. Like on the one hand, we want to change the law because it's so unfair that we have to do this. But on the other hand, as long as we still have to keep doing this, we want to make it easy. And when Sustainable Economies Law Center, the nonprofit I run, one of our purposes is to educate people about all this stuff. And we have different areas of law that we focus on, but this is one of them. And we're working on an FAQ that's going to go through all of this stuff. And we're also partnering with this another nonprofit to create this book called the Capital Cookbook that's going to talk about different ways to raise capital and have like forms you can use for different types of capital raising. So hopefully little by little this will become more accessible to people. I mean, it's very complicated, and there's like everything, each state has like 10 different things, and it's so damn complicated. But little by little, we'll start to compile all that information into a usable form, and hopefully people will be able to start taking advantage of that.